welcome back to another episode at Divorce at Altitude. Today I have with me a colleague and friend, Laura Koupal. How are you doing, Laura?
Good. Thanks for having me, Amy.
Yeah. Funny story about Laura and I, we used to work together, back in the day. I was a young associate when she was a senior associate. So, since that time, Laura, where has your practice taken you?
So I am now a solo practitioner, and my law firm is Koupal Law Firm, and I specialize in the area of fertility law, which is a subsection of family law. And so my practice is solely focused on representing surrogates, intended parents, egg donors, sperm donors, and then I do a little bit of familial adoption, so like a step parent or second parent adoption.
Wow, that's a really interesting area. I'm sure you really like doing that.
Yeah, I love it. It's been a great fit. We have clients from the United States and all over the world that come to Colorado to do fertility treatments. And Colorado's kind of a well-known fertility hub because we have the Colorado Center for Reproductive Medicine, the University of Colorado Conceptions, some really well-known fertility clinics here in Colorado. And so it's great to be able to connect with people kind of from all over to do this type of law.
Yeah. And I have friends who have, dealt with that, and you probably meet really interesting clients, and your work can really help people grow their families. So that's really cool. Before we kind of get into, like surrogacy and the history in Colorado, are there any other, terms that we need to discuss what they mean, like the definition that would be important?
Sure. So the work that we do always involves assisted reproduction. So assisted reproduction is a method of causing pregnancy through means by other than sexual intercourse.
Okay.
And then surrogacy is there's two types of surrogacy. There's a genetic surrogate, who's an individual who's not an intended parent and who agrees to become pregnant through assisted reproduction using their own donated gametes. So their own egg is used. So that's a genetic surrogate. And then a gestational surrogate is an individual who's not an intended parent and who agrees to become pregnant through assisted reproduction using gametes that are not their own. So those gametes would be either the sperm from the intended parent, an egg from an intended parent, or an embryo that was donated to those intended parents.
And one thing I'm just thinking about is, how did Colorado become such a hub for fertility?
So Colorado just has renowned fertility clinics. And so those fertility clinics include the Colorado Center for Reproductive Medicine in Lone Tree, the University of Colorado, and Conceptions are three of the biggest fertility clinics that we have here in Colorado.
And is that how surrogacy kind of evolved, because there was, the fertility clinics here? Was that part of?
Yeah, surrogacy became more popular in the last, I would say 20 or so years, because the fertility clinics were getting really high success rates on IVF treatments. And once those IVF treatments became successful, above 85% of the time, people were more inclined to start considering using a surrogate to help them start their family.
So I guess what else is important with kind of the history of surrogacy in Colorado?
So surrogacy has happened in Colorado for a long time. And we were using existing parentage laws to establish the parental rights for intended parents, and creating contracts between the surrogates and the intended parents, including contracts that were altruistic, where the surrogate wasn't being compensated, or compensated surrogacy agreements, and this was working out really well. And we were able to establish the intended parents' parental rights through the court system. But as we know, bad facts can create bad laws. And so we worked the last 3 years to establish a statutory framework that clients can rely on, and we passed that statute in May of this year.
Wow. So
that
pretty new.
Yeah, so it's a brand new statute. The statute is in Title 19, and it's 19.4.5101, and the statute is called the Colorado Surrogacy Agreement Act. And so that's a great piece of legislation for both the intended parents and the surrogates, because it protects the surrogates and that they don't have any financial responsibility or any other responsibility for the child. It allows them to receive compensation, and it allows them to bring a claim under the act in the event that there was a dispute. It also protects the intended parents because it clearly establishes their parental rights and responsibilities for the child. It allows their names to go on their child's birth certificate. It provides a framework for them also to provide compensation to the surrogate, when appropriate. And it provides protection for the resulting child, because the child then, has a clear legal framework that they're the child of the intended parents. And so, it allows them, again, to have that birth certificate with their parents' names on it. And then it allows their parents to get social security cards for them, passports, whatever they might need to fully secure their rights.
And where does Colorado sit as far as other states? Like, do other states have a similar statutory framework, or is Colorado kind of leading in this area?
So every state has their own surrogacy laws, and the majority of the states are states like Colorado used to be. So the majority of the states are states where the state doesn't permit or prevent surrogacy. But there are 11 states, including Colorado, that have specific surrogacy laws. I think ours is one of the most comprehensive surrogacy laws out there. Our statute contemplates both the genetic surrogacy and the gestational surrogacy piece of it. So I think that's one of the things that really sets our state apart. The statute's interesting in that it really just codifies the practice that we were doing before, and it doesn't really have any other. It doesn't create more sort of barriers to entry, So it's really just, like I said, kind of codifying what we were already doing. It does have a few kind of requirements. Do you want me to go through those?
Yeah, that'd be great.
So the surrogate and the intended parents have to be over the age of 21. The surrogate needs to complete a medical evaluation and a mental health consultation. The intended parents also need to complete a medical evaluation. And then the surrogacy agreement needs to be written out, and both parties have to be represented by individual attorneys that are licensed in the state of Colorado.
And then is there anything that was different about being represented by licensed attorneys in the state of Colorado? Has that always been?
That hasn't always been the case. So typically, best practice was considered to be that at least one attorney should be licensed in the state where the contract was governed under. So we would have instances where, the surrogate would be represented by Colorado counsel and the intended parents might be represented by an attorney in a different state. So that would be considered, a new practice. But historically, best practice has been that at least one person is represented by Colorado counsel. And part of the reason for that is when we establish the intended parents' parental rights through the district court, obviously you have to have a license in Colorado to do that. So, I mean, that's part of the rationale for it.
Yeah. So when someone comes into your office, can you just explain, like how long the process takes? I know it depends on what they're doing, but if it's, like a straight, like surrogacy type case, like what are the steps? How long does it take? If you could just walk us through what that looks like.
Sure. So the majority of clients are matched through a matching agency. And when clients are matched through a matching agency, they've usually done a lot of the kind of the legwork. So they've met each other, they've agreed to certain compensation terms. A lot of times, but not all the time, the surrogate's already completed her medical evaluation and her mental health evaluation. So from that standpoint, they kind of present to us as attorneys as ready to go. And so we draft their contracts at that point. Typically, the intended parents attorney drafts the contract. So I would draft the contract for intended parents. I'd set up a time with them to go over the contract, make sure that we've included all of the terms that they want, either from a personal standpoint or from an agency standpoint, like a fee agreement that they've already agreed to. And once that contract looks good from our standpoint as the intended parents, then we send it over to the surrogate's attorney, and the surrogate's attorney then reviews it with the surrogate. They kind of do the same thing, make sure that the surrogate understands all of the terms of the surrogacy agreement, make sure that there's not anything in there that was missing or that she wants to include. They send it back to us for negotiation. It's not a, litigious process. If it's obviously, people who are entering into a very intimate agreement. So it's kind of a collaborative process. But once the agreement kind of looks the way all of the parties want it to, then they execute it. That process typically takes about a month. By the time you kind of, get on everybody's calendars and go through it. And then the attorney for the intended parents issues what's called a legal clearance letter to the fertility clinics. And then the fertility clinics will start with the medication cycle and a transfer date. From there, the lawyers don't really do anything until the surrogate's about 15 to 18 weeks pregnant. And at that point, we file a petition for determination of parental rights with the district court, and that process allows the magistrate or the judge to issue an order that says that the surrogate and her partner are not the parents, the intended parent or parents are the parents, and that the intended parent's name should go directly on their child's birth certificate. And so that order is really helpful for a couple of reasons. One, the intended parents are able to take that order to the hospital when their child's born, and the hospital will band the child with their names. They'll use their health insurance for their child, and they're able to make medical decisions for their child, discharge their child, things like that. And then secondarily, that order then goes to the Department of Vital Records, and Vital Records will issue their birth certificate.
Yeah, thank you for going through that. And I kind of remember working with you that sometimes there would be a medical power of attorney, like for the unborn child. I don't know if that's exactly what it was called, but is there sometimes like those directives, like do you get involved with, what happens if the surrogate, something happens during, the birthing process? Can it get kind of complicated?
Sure. We do typically recommend that the surrogate issue some of those directives, and examples would be like a living will, a medical power of attorney for the unborn child, where she would list the intended parents as the agent, and then a medical power of attorney for herself, where she would list her own agent, typically a spouse or family member. Fortunately in my practice, we haven't had to use those documents, but, I think that would probably be considered to be best practice to have those on hand, in the event we needed something like that.
Yeah. Have you seen in any of your cases over the years, where there's issues with, like, do parties ever fight over the contract or terms of the contract? Has anything ever had to go to arbitration or anything like that?
Thankfully in my practice, no, I haven't experienced that. When clients go through the process and jump through the hoops in the way that it's sort of intended or what would be considered best practice, there tends not to be a lot of problems. So best practice would be considered to, make sure that their surrogate's fully vetted. So whether they use an agency to do that or they do it on their own, they're going to want to make sure that their surrogate is, she's previously given birth to a child, that she has, a reliable background. So you would do a background check to make sure that there's not criminal history, that she hasn't filed bankruptcy in the last 5 years. You would want to make sure that the parties have met each other. And again, that the surrogate's undergone the medical and the mental health evaluation to be a suitable candidate. And then from there, you want to make sure that they have reputable, experienced attorneys, that they're using a reputable fertility clinic. So for the most part, when the clients sort of check all of those boxes, they really have successful outcomes.
Yeah. Yeah, no, that's interesting. One other question I had is, does the surrogate, is she under her own insurance, and then the onboard child is under the intended parent's insurance? That's what you
Yes.
said? Okay.
Yeah, that's right. So that's another thing that the intended parents would want to consider, and they would look to see if the surrogate's insurance would cover her medical bills, pre and post delivery, if she's acting as a compensated surrogate. So there's options if she doesn't have insurance, or if her insurance doesn't cover, then the intended parents can purchase a health insurance plan for her.
Do you see a lot of clients who might have like a family member serve as a surrogate?
Yes, that definitely happens. And those matches can be altruistic, so uncompensated if they want, or they can be compensated, depending on what the needs of the parties are. But you can draft an agreement, or you can reach an agreement that really says anything in terms of compensation, just so long as the parties agree. But even if it's your, friend, sister, cousin, coworker, you still need to have a surrogacy agreement, and both parties still need to be represented, because there's things that you maybe haven't thought of, and that sometimes it's hard to have some of those conversations about things you may or may not be worried about or need. And so, lawyers can kind of, help you have your own voice, and making sure that you're all comfortable with the agreement.
Yeah. And I think it's important not only for clients, but family law attorneys to understand kind of your nuanced area. So that kind of segues into, is there anything else regarding the Colorado Surrogacy Agreement Act, that you think it would be interesting or important for family law attorneys or other clients to know about?
No, I think that from a family law attorney perspective, it's just important to understand that the intended parents really are the parents of the child. It's not an adoption, and it's different on a number of different levels. So just kind of to understand what surrogacy is, I think could be helpful if your client has children through surrogacy. And then I think another important part is to remember that a lot of these families have embryos that are cryopreserved and stored. And those embryos, there's case law that we have in Colorado dealing with those. And the Remarriage of Rooks was the most recent case.
Right.
But just talking about the fact that embryos are special property, and that they really do need to be addressed in a separation agreement. So that I think it's always important to ask clients if they have cryopreserved embryos, and kind of take that into consideration
Yeah.
through the entire divorce process.
Yeah, because it's something that you kind of forget about. So it's almost, we've considered putting something like that as like on the intake form, just, something to check the box, kind of like how you would with if you have estate planning, because it's easy to forget about something like that. I guess if you're a family law attorney, and that there was a surrogacy, or, the parties are going through a divorce and there's, surrogacy going, in the middle of it, what type of discovery would you need to ask for? Like, what exactly is the contract called? Like, would you need to subpoena documents from the fertility clinic? What would be helpful, do you think, from a family lawyer's perspective to get as far as discovery?
So the Colorado Surrogacy Agreement Act actually addresses the issue of what would happen if the parties were to get divorced while a surrogate's pregnant. And so the that's under Title 19 4.5 107, and it says effect of subsequent change of marital status. So if either the surrogate were to get divorced or the intended parents were to get divorced in the middle of a surrogacy, and that would be while the surrogate's pregnant, the parties need to understand that they still need to move forward under the terms of the agreement. So the agreement is typically called really just a surrogacy agreement, and that's the direct agreement between the parties. So the direct agreement between the intended parents and the surrogate and her spouse if she's married. And so you could ask for that agreement, but really, I think just to understand that a change in marital status doesn't change someone's obligations under their agreement. So just because you're getting divorced, let's say you used donor sperm, the intended mother's egg, and entered into a surrogacy agreement, the surrogate's pregnant, the intended father can't say, oh, never mind, I don't want this child anymore, I'm not even genetically related to the child, because of his intent to parent the child, create the embryos, and use the surrogate. He would still be considered financially responsible for the child under the law.
Okay, and then let's just talk about, you had mentioned Remarriage of Rooks as being a very recent case in Colorado. Can you just explain what happened in that case briefly, like how it changed or clarified the law?
Well, basically, I think the case dealt with what happens if you have an agreement through, like, on a consent form, and the consent form then says that it kind of just kicks it back to, well, you have to decide, a court of law has to decide, or the parties have to decide, and then the Rooks case kind of goes through the analysis of, if there's an agreement in place, the court will consider the agreement that's in place. If there's not, then the court will make a determination.
So when you're going through a divorce, like, not only do I put on my intake form, if you have embryos, but we had discussed, addressing it in the separation agreement. Would you specifically, the language is essentially around who owns the embryos, correct? Like, what are some other scenarios that you could see that would need to be addressed in, like, a separation agreement?
Yeah, so the parties there's a couple of things that you can do with cryopreserved embryos. You can say that the ownership goes to the intended mother, the ownership goes to the intended father, or, if it's a same sex partnership, the embryos can be divided between one partner or the other. The embryos could be thawed. So basically destroyed. They could be donated to research, or they could be donated to another couple. And, if the parties can't decide, then the court's going to make a determination for them. So it's really in their best interest to decide. I think technically the parties could also decide to split the embryos. So let's say they had 4 and they each wanted 2. The difficulty in that is just embryos have different quality. Embryos are gender specific. It's kind of hard to do that. And I would say the majority of clients do not choose to split the embryos. But when you're kind of making a consideration on what to do with the embryos, a lot of times the court will look at, is this the intended parent's last opportunity to have a biologically related child to them? So have they gone through cancer treatment, and, removed their eggs or sperm in preparation for that treatment and no longer have the ability to have a biologically related child? The court would take something like that into consideration. If the parties both, say that their family's complete, they have resulting children from the embryos, and or both parties are able to kind of continue to procreate or create, have another egg retrieval or another sperm retrieval, then I think the court is less likely to award the embryos to a party if the other party doesn't agree to it.
Yeah, it's been a while since I drafted a provision in a separation agreement, but the scenario I had is my client, she had embryos because she had cancer, and so it was kind of her last chance to, have kids in the future. And how I addressed that in the separation agreement was that she was going to keep them. But I also, I did address, the fact that the soon-to-be ex-husband wouldn't have, parenting rights and be financially obligated. But at the time, that was before even In Remarriage of Rooks was out. So, even as a family lawyer, you need to address it, but it's sometimes hard to exactly know if you're, covering every scenario. Does that make sense?
Yeah, no, that does make sense. And that is correct. So if the parties are going through a divorce and one partner is awarded the embryos for their sole use, so that they can either use them to transfer to themselves, a gestational carrier, to thaw, to donate to research, whatever, then that absolves the other partner from having any responsibility for any resulting child. So, that is an instance where, I think it's most similar to the parties being divorced and that spouse going on to have a child with someone else, where the ex doesn't have any rights or responsibility for that new child, even though with an embryo, the ex could be genetically related to the child. That partner that doesn't have the embryos is no longer responsible.
Right. And then is that by chance codified now, like in the Colorado Surrogacy Agreement Act?
It is.
Okay.
And so I think you can look back to that 19.4.5, 107.
So it's probably a really good idea for any divorce attorney to, really be familiar with that act, to at least review it.
Yeah, I think, and it's interesting, when we're talking about family building, there's just a lot of different ways that families can be built in Colorado. And I think that it's good to kind of understand, how clients are creating their families. The other thing that the Colorado Surrogacy Agreement Act addresses that I think is interesting, and this is also in the UPC too, but we talk about, parentage being defined, if one of the parents is deceased. And so it defines, what if you use an embryo that was created after one of the parties is deceased. And so that's under 19.4.5.110. And again, that's also a law, sort of a little known law that we've had under the UPC too.
Yeah, no, that is good to know. Let's talk a little bit about, you also mentioned you do some adoption work as well. Is that correct?
I do. So primarily I do adoption work for same-sex clients who have used assisted reproduction. So a lot of times that's a same-sex female partners who have used a sperm donor. And if the partners are married, then there's a presumption of parentage if they have a child during the marriage. So you can use that presumption of parentage to have both of the partners listed on their child's birth certificate at the time of delivery. So they can go into the hospital. One parent delivers, the other parent, again, through this presumption, is listed on the birth certificate. A birth certificate's considered prima facie evidence of parentage, so it's the best evidence you can have that you're the parent, but it's not a court order of parentage. And so some clients get nervous about that, and they want a court order that is granted full faith and credit in all 50 states. And so the way to establish that, or the way that I establish that in my practice, is through either a step-parent adoption or a second-parent adoption. And basically, we'll just petition the court through the adoption to leave the birth certificate as it is, but to create an order, a decree of adoption that says both parents are equal parents of their child.
Yeah. And I mean, I don't know a ton about adoptions, but like, do they have to go through and get like, the fingerprints and, background checks from the FBI? Like, I guess my question is it a onerous process or is it pretty easy?
For the most part, it's pretty easy. If they do a step-parent adoption, you do have to do those fingerprints. So you do FBI, CBI, and Trails fingerprints. But then, again, there's nobody contesting the adoption.
Right.
So once you get a hearing with the court, it's a nice, sort of easy hearing. Both parents come with their child, and it's, I think, a lot of the magistrates and judges' favorite part of their day in juvenile court.
Yeah, I was gonna say it's like the one time that they'll actually like take pictures.
Right, exactly. And then if you do a second parent adoption, there is a component in the second parent adoption statute that requires a home study. Again, the process isn't meant to preclude or prevent people from parenting their own child. And it's not, again, a contested process, but it's a process.
Yeah, I've always wondered, like, what is a home study, and like, what exactly is a home study? Like, what's involved?
So the home study for this type of case would require kind of financial background checks, physical checks for the child and the parents. They might do an interview with friends or family members. It's invasive. It's not so invasive that families don't do it, but, it's another step, and it's probably not a necessary one, given that these are intended parents who have really wanted this child for a long time and have already gone through a lot of steps to create this child and provide a good home for the child. So, I don't tell, clients shouldn't consider the home study a reason not to go through the adoption, but in my personal opinion, it's a little much.
Yeah, yeah, I could see that. Well, is there anything else, Laura? Like, your area is so interesting. Is there anything else, like nuances within your kind of practice area, that you think would be helpful for a family lawyer, to flag, I guess, to at least be aware of, in a divorce action?
No, I think that we've really covered kind of the big topics. I'm always available to answer any questions if anybody has any, or if a family law attorney wanted me to review a provision in a separation agreement or something like that, I'd be happy to help. I think that the biggest takeaway probably is just to ask clients how they form their families. Don't make assumptions. Remember that families can be formed in a lot of different ways. And that might have an implication on a separation or a parent agreement or a parenting plan.
Well, great. Well, thank you, Laura, for coming on our show today. If you could just tell people how can they reach you if they had questions or their potential clients.
Sure. I have a website. It's koupalaw.com, and it's KOUPALLAW.com. And my email is just laura@koupal.com.
Well, great. Well, thank you, Laura. I really appreciate you coming on today. This is a super interesting topic and, something that, makes me I need to go read the Colorado Surrogacy Agreement Act now. So I'm
Thanks
familiar.
for having me.
Okay, thank you.
Appreciate it.